My name is Bruce Garren, and I'm the chairman of Personhood Kansas. There are 10 states where activist Supreme Court justices have created a fundamental right to abortion in the Constitution: Alaska, California, Florida, Iowa, Kansas, Massachusetts, Minnesota, Montana, New Jersey, and New Mexico. By placing abortion on the state constitution, pro-abortion state courts are ensuring that abortion on demand will continue even if the Supreme Court overturns Roe v. Wade. In all of the cases where a fundamental state right to abortion was created by activist courts, this was done through legal challenges to pro-life laws that sought to regulate abortion. This is important to note because proponents of Personhood Amendment are often told that Personhood Amendments would set back the movement. Yet, as we can see, the insistence of some pro-lifers on passing laws that regulate some abortions and allow others to continue is precisely what allowed the state courts to create these fundamental state rights to abortion. Now, there are several possible responses to judicial activism that has forced Kansas to adopt this fundamental right to abortion. One totally unacceptable option is to enshrine within the state constitution some form of abortion regulation. This would be catastrophic for several reasons. One, pro-lifers do not seek to regulate the manner in which children are killed. They seek to protect them from being killed. Two, inserting abortion regulations into the Constitution would ensure that future state legislative progress is limited to those regulations within the Constitution. And three, it would create a separate basis to keep abortion legal in Kansas if and when the federal right to abortion is overturned, ignored, or denied. A possibly less catastrophic option is to write into the state constitution language specifically denying that there is a right to abortion, but without requiring any action to protect the preborn. This amendment would implicitly write into the state constitution a notion that preborn children have no fundamental right to abortion, to life. The third approach is one that you already have introduced in the legislature and which deals with the problem at hand in a fundamental and consistent manner. This is the Personhood Amendment. The Personhood Amendment simply recognizes that the child in the womb is a person with basic fundamental rights of any other person. It is the most clear and concise rebuttal of those who dehumanize the child in order to justify abortion. A Personhood Amendment would use the very same logic used by the Kansas Supreme Court that Section 1 of the Kansas Constitution Bill of Rights sets forth rights that are broader than and distinct from the rights of the 14th Amendment to the United States Constitution. But instead of protecting the right to abortion, the state constitution would protect the right to life. While this approach would still be open to attack from federal activist courts, it would, one, ensure that protection of preborn babies in Kansas once Roe v. Wade is overturned or chosen to be ignored or defied. Two, immediately guarantee protection for preborn babies in a myriad of cases, such as wrongful death, fetal homicide, chemical endanger, and many other non-abortion related cases. And three, provide for solid foundation upon which to challenge the federal judiciary created right to abortion. Personhood Kansas therefore recommends swift passage of House Concurrent Resolution 5004 and Senate Concurrent Resolution 1604 amendment, which says, recognizing the authority of the state of Kansas to exercise its police power and its sovereign right to adopt individual liberties in the Constitution of the state of Kansas, more expansive than those conferred by the Constitution of the United States, the state of Kansas hereby guarantee the inalienable rights, equal protection, and due process of the law of every human being from the beginning of the biological development of that human being including fertilization.